Bismillahirrahmanirrahim. Honorable Justice Aisha Shudun Muhammad was Senior Judge, Supreme Court of Mali. Honorable Justices, High Court Division, Supreme Court of Bangladesh. Her Excellency Ms. Shuni Rashid, High Commissioner of Maldives to Bangladesh. Distinguished members of the bench and the bar, respected mediators, honored speakers, and esteemed guests from India, Nepal, Bhutan, and Sri Lanka. Assalamu alaikum and good afternoon to you all. It is a privilege to join this distinguished gathering in the honor of Justice Aisha Shuduni Muhammad, Honorable Justice of the Supreme Court of Maldives, whose career reflects a remarkable blend of judicial depth and institutional leadership marked by her eminent contributions across private practice, the judiciary, and public service. Her distinguished engagement with the global human rights jurisprudence and at the same time her work in judicial governance and legal education reminds us that building a justice system is not only about deciding cases, but also a commitment to strengthening the rule of law and nurturing the next generation of legal minds. Distinguished audience, turning to the theme of today's discussion, if we look consciously at our own legal system in Bangladesh, mediation is already there, firmly embedded in law. At its core, mediation has been statutorily recognized as a flexible, informal, confidential, and non-adversarial process where the mediator facilitates settlement without imposing a decision. Mediation in Bangladesh is not confined to a single statutory framework. Rather, it has been progressively embedded across a wide spectrum of laws, reflecting its growing institutional significance. For example, the Code of Civil Procedure 1908 mandates mediation through sections 89A to 89C, making it an integral part of civil litigation. These provisions empower courts to either conduct mediation themselves or refer disputes to trained mediators or legal aid officers, but the framework extends far beyond the same code. Mediation finds expression in the Order in Adalata in 2003, which facilitates settlement conference in financial disputes, not only during the course of trial, but also at the stage of execution and even after disposal of execution proceedings. Within the evolving family law regime, formerly under the Family Courts Ordinance 1985 and now under the Family Courts Act 2023, reconciliation stands as a mandatory step to be undertaken prior to the final adjudication of disputes. The Bangladesh Labour Act 2006 incorporates mediation in the resolution of industrial disputes at the grassroots level. Additionally, fiscal statutes such as the Value-Added Tax and Supplementary Duty Act 2012, the Customs Act 2023, and the Income Tax Act 2023 provide avenues for alternative dispute settlement in revenue matters. Even within criminal jurisprudence, the concept finds limited recognition through the framework of compoundable offenses, where elements of negotiated settlement are permitted, thereby demonstrating the cross-sectoral integration of mediation within the legal system. The Legal Aid Services Act 2000 institutionalizes mediation through state-supported legal aid mechanisms. Mediation is one of the vital services provided by the district legal aid officers and the Supreme Court Legal Aid Office under the SAID Act. As of March 2026, 1,99,957 cases have been resolved successfully through mediation. Esteemed guests, a significant development in this regard is the enactment of the Legal Aid Services Amendment Ordinance 2025 and 2026, which came into force on 1st of July 2025 and 7 January 2026, respectively. The First Amendment Ordinance of 2025 introduces both pre-case and post-case mediation, allowing disputes to be resolved either physically or virtually through mutual compromise. Most notably, following the amendments, the schedule to the Legal Aid Services Act 2000 incorporates mandatory pre-case mediation in a wide range of disputes, including family disputes, preemption disputes, land disputes relating to partition travel by the civil judges, negotiable instruments and checks, dishonor cases below Taka 3 lakh, rent control matters, and more controversially, dowry-related disputes. The ordinances also enlarged the number of mediators at district level by creating 2 additional posts of chief legal aid officers and special mediators, along with the existing post of district legal aid officer. Most importantly, Section 21C of the Ordinance 2025 made the mediation agreement, once signed by the parties and the mediator and certified by the chief legal aid officer, is final, binding, and enforceable. It is deemed to be a court decree or order and can be executed through a competent court. Previously, parties often failed to comply with mediated settlements, forcing the other side to initiate fresh litigation. These undermine the purpose of mediation and added to the burden of minor cases in courts. By making such agreements legally binding, the amendment ordinances introduce a significant and necessary reform. A further development in this area has been the introduction of a new subsection to Section 345 of the Code of Criminal Procedure 1898 by the Criminal Procedure Amendment Ordinance 2025, ratified as an Act of Parliament on 10th April 2026, which empowers the court to refer the petty criminal disputes to the district legal aid officers for mediation purposes. This legislative shift attempts to institutionalize mediation at the very threshold of litigation. Yet, the question arises, how often mediation is treated as a real opportunity rather than just another procedural step? The National Legal Aid Services Organization suggests that 90% of disputes are actually capable of settlement through mediation, a finding that closely aligns with the global commitment under United Nations Sustainable Development Goals, particularly Goal 16, which aspires to ensure access to justice for all. So perhaps the issue is not whether mediation works. Rather, the real question is why it is not being utilized to its full potential. Dear audience, mediation in the context of socio-economic condition of Bangladesh is often shaped by social realities like inequality, power imbalance, and sometimes by fear. For example, In family disputes or cases involving women, it often remains a matter of concern where the parties are negotiating freely or acting under pressure. In practice, mediation in Bangladesh often takes an evaluative form, where mediators actively suggest possible outcomes. While this is not inherently problematic, it calls for caution to ensure that the process does not become overly directive or authoritative, thereby undermining party autonomy. Alongside these conceptual concerns, several procedural limitations also persist. For example, although mediation is mandatory under the Code of Civil Procedure 1908, the absence of effective consequences for non-compliance weakens its practical enforceability. Further, there is no structured provision ensuring the presence of female mediators in gender-sensitive disputes, which remains a critical gap. Then comes the issue of digitalization or lack of awareness about mediation process. We speak increasingly of online mediation, but a large portion of our population still lacks digital access or literacy. If we move too quickly without addressing that gap, there is a risk of creating a system that is efficient but not inclusive. Distinguished presence. Across South Asia, mediation has developed largely as a response to structural constraints within formal justice systems, particularly in the backdrop of chronic case backlog, limited judicial resources, and unequal access to legal services. In India, Section 89 of the Civil Procedure Code, as amended in 2002, formally institutionalized court-referred ADR mechanisms, while the Mediation Act 2023 further strengthens a structured mediation regime with provisions for accreditation and enforcement of settlements. Nepal has adopted mediation more explicitly through the Mediation Act 2011, establishing community mediation centers aimed at local dispute resolution. Sri Lanka, meanwhile, has a relatively distinctive model based on the Mediation Boards Act 1988, which makes pre-trial mediation mandatory for a wide range of minor civil and criminal matters through community-based mediation boards. In Bhutan, mediation is formally recognized under the Alternative Dispute Resolution Act of Bhutan 2013, reflecting the country's emphasis on harmonious dispute resolution aligned with its philosophy of gross national happiness. The mediation system in the Maldives has developed as an integral component of its broader justice delivery framework. It operates alongside the formal court system and is designed to resolve civil, family, and minor criminal disputes through consensual settlement rather than adversarial litigation. The judiciary actively facilitates settlement of courts by referring appropriate cases for mediation at various stages of proceedings. Across the region, socioeconomic conditions continue to shape mediation as a necessity-driven mechanism rather than a fully professionalized dispute resolution industry. Honored presence. Today, as we honor Justice Aisha Shujuni Muhammad, we are reminded that a modern judiciary must go beyond adjudication and strive to resolve disputes in a manner that responds to human realities. We are sincerely grateful to our guest of honor for gracing this ceremony with her presence, strengthening the close bond between Maldives and Bangladesh through the sharing of knowledge and experience, particularly in the field of mediation. We also extend our heartfelt appreciation to our distinguished guests from India, Nepal, Bhutan, and Sri Lanka for their valued presence and contributions. Our sincere thanks are due to the organizers, Bangladesh International Mediation Society, Bangladesh Mediation Forum, and Supreme Court Mediation Forum for arranging this meaningful occasion. This August gathering today reflects the growing importance of cross-border dialogue, regional cooperation in the evolution of mediation. It opens the door for deeper collaboration among our countries, fostering the exchange of ideas, experiences, and best practices in shaping more responsive legal systems. Mediation, in this regard, stands as an effective and people-centered process to resolve disputes efficiently with mutual understanding. As we look forward, the prospects of mediation in Bangladesh remain promising, yet they call for significant commitment from all stakeholders in civil society. Let this occasion reaffirm our dedication to strengthening mediation and enhancing cooperation between our jurisdictions towards a more responsive and inclusive system of justice. Esteemed presence, after listening to the insightful remarks of so many distinguished speakers, I extend my sincere gratitude to all of you for your attentive and thoughtful engagement with my address. Thank you.